Commercial activity exception, legal framework and sovereign immunity limitations. Introduction to the commercial activity exception. The commercial activity exception is a legal doctrine that limits the sovereign immunity of governments and foreign states in cases where they engage in commercial transactions or business activities. Under U.S. law, Foreign Sovereign Immunities Act, FSIA, 28 U.S. C. Section 1605a, 2, a foreign state can be sued in U.S. courts when it participates in commercial activity similar to that of a private entity rather than performing governmental functions. This doctrine ensures that sovereign immunity is not used as a shield against commercial liabilities. Purpose of the commercial activity exception: prevents abuse of sovereign immunity in business dealings. Allows private parties to hold foreign governments accountable in commercial disputes. Ensures fair competition between government-owned businesses and private corporations. Encourages foreign states to engage in ethical commercial practices when operating internationally. Legal basis for the exception: Foreign Sovereign Immunities Act, FSIA, 28 U.S. C. Section 1605a, 2, defines when a foreign state can be sued for engaging in commercial activity. United Nations Convention on Jurisdictional Immunities of States and Their Property establishes global standards on sovereign immunity limitations. Common law principles recognize that governments acting as market participants must adhere to commercial liability laws. Key legal implications: sovereign immunity does not apply when a government engages in commercial activities similar to private businesses. Foreign states can be sued in U.S. courts if their business dealings have a direct effect in the U.S. Government contracts, property transactions, and financial dealings are subject to the same legal responsibilities as private corporations. International businesses can seek legal recourse against government-owned corporations in commercial disputes. Examples of commercial activity subject to litigation: 1. Government-owned businesses, when a state-owned enterprise, SOE, engages in international commerce. 2. Breach of contract, if a foreign government fails to honor a commercial agreement. 3. Financial transactions, when a government issues bonds, loans, or other financial instruments. 4. Real estate and property sales, if a foreign government buys, sells, or leases commercial property. 5. Trade and investment disputes, when a foreign state is involved in international business ventures. Limitations and defenses: a government's purely sovereign acts remain immune, e.g., taxation, military actions, legislative acts. The commercial activity must have a direct effect in the jurisdiction where the lawsuit is filed. Foreign states may invoke diplomatic protections to challenge jurisdiction. International treaties may impose additional conditions on sovereign immunity waivers.